Good evening, all. Thank you. I still see the audience, which is a great thing. I know we have been asked to be conscious of time, so I will directly kick into our session for the evening, which is the last session for the day. I have a very esteemed panelists with me, starting with Dimitris, who is working with American P&I Club, and with us today, followed by Siddharth Ranka from Binocle Legal Services, Dubai, and Ruchir Goenka from Bros and Mitra. With that, we will kick our session for today, and I will keep it into questions, starting with Dimitris, with you first. What, in your view, are the key risks looming with the potential to impact or continue impact maritime trade and business in the coming days? We know it's been uncertain days and uncertain times, but what is your insight on that?
Sure, thank you. Thank you all for sticking around. My thanks to the previous panel for accelerating their discourse for my benefit as I have a flight to catch. And my thanks to Maritime CEO for yet again an amazing event the last 3 days. The topic I feel presents the biggest risk at the moment is a topic we discussed earlier, and that's sanctions. With that said, because we do live in interesting times, I should start with a disclaimer, which is that even though the American P&I Club has American in its name, we're not affiliated with the American government. So people have strong opinions about sanctions. I'm here to neither defend nor promote the American government's actions. That said, as a Greek, I feel I owe everyone a small apology on sanctions because, like many things shipping, it appears sanctions are also a Greek invention. 2,500 years ago, my city, Athens, passed a decree effectively sanctioning a neighboring city, Megara, for their alliance with Sparta. Allegedly, that led, or was one of the causes of the Peloponnesian War and the end of the golden era of ancient Greece. So, query whether sanctions work. But 2,500 years fast forward, the last 3 years, we've seen increasing sanctions and an even more ramping up in the last few weeks and months. We have a situation where allegedly about $450 billion of Russian money has been immobilized. We have a situation where the EU, the UK, and the US are becoming more coordinated and are implementing stricter and stricter sanctions. I think everyone knows that Lukoil and Rosneft were the latest targets by all. Effectively, that means that pretty much every Russian seaborne crude oil exporter is now sanctioned. At the same time, there are increasing concerns that the shadow fleet, which now numbers about 1,700 vessels, 1,000 of which are aging tankers, is leaking oily discharge as it's passing through waters. We've had an incident just the other day where a sanctioned vessel grounded as she was passing the Suez Canal. Mercifully, it was a minor incident. But interestingly, she was only one of 4 ships in the same convoy that was one of the Dark Fleet vessels. So the EU, the UK, the US are responding as they see fit. And I think for me and for us here, one of the biggest questions really is how this affects India and how India will react to what's going on. So we know that historically India did not really purchase that much Russian oil. That happened really very much after the war in Ukraine. And I should be very clear in saying that this was with the explicit blessings of the international community. And it has benefited India, of course, as it would, buying cheaper oil, but it has benefited, frankly, all of us by keeping oil prices low. So India and the rest of us, but India in particular, because we are where we are, is faced with a very serious dilemma right now. There is no question that anything that India is collectively doing is illegal or sanction busting at the moment, but we don't know what the reaction will be. The US alleges that as a result of its pressure and increasing tariffs, India has drastically cut its its Russian crude oil imports. I have not seen any official statement from India at the moment. But the dilemma is this: risk retaliation from the US, or try and buy, if India can, oil from somewhere else. The difficulty with that, of course, is that the oil that India buys works for its refineries. To buy lighter crudes from other sources, even if it was available, because it's committed long term, even if OPEC reverses its stance and opens up the spigots, the question is that it will increase the cost for India. There will be huge outlay for the refineries to adjust their operations to those oils. And perhaps more importantly for India itself, this will lead to higher domestic prices of oil. So what does the Indian government do? Do they risk retaliation, or do they risk the discontent we know comes in every country when when oil prices go up?
Indeed. In this context, what do you think? Is there any preparedness which comes to your mind? Do you think if you were taking Indian administration's hat on, what do you think would anything help or benefit?
Sure. I mean, check your emails every day and twice on Sunday. I mean, I think both this panel and previous panels had to scrap half of what we had to say because of what happened in the last day. On a more serious note, I think the sanctions environment now is so complex and fast evolving that unless you're operating in a substantial organization, it is impossible to keep up on your own. As a P&I club, you as a member or any member cannot delegate that task to us, so you have to look to an increasing array of external providers who will assist you with doing those searches, and it's a growing cottage industry.
I fully understand there is no right or wrong in this equation when we look at it from all the angles. But I will then also check with Siddharth if you have any comments to this sanctions as a risks.
I mean, yeah, sure. I mean, sanctions as a risk, I mean, it's a age-old story for a long time. But the recent trend shows that more than lawyers, compliance officers in companies are the going after job, maximum vacancies there. I mean, sanctions has direct and indirect impact, especially on India and countries outside the EU, US, and UK. And people seem to sometimes ignore the fact that the world is so interconnected that a bank in India would still have to do a compliance check. And it will be red flagged if there is a company which is sanctioned, UK or the US. So India may still say that we do not follow the sanctions, but the banks may have a branch in the US which has exposures. So I think this is sometimes not overlooked. If you're looking to do international business, which I think most of us in this forum are interested in, it's something to be mindful of. I think invest in a compliance software maybe. Start with at least.
Oh, thank you. Ruchir, do you want to add anything to what has been said?
Yeah, I mean, it's definitely changing because in the recent past, we've never really had to do sanction checks. We just gave the advice. It was pretty easy dealing with money and everything. But we have noticed that things are changing now, and clubs are more careful about who money is being paid to. Even when they're trying to enter into settlement agreements, there are sanction checks being conducted on them. But from an Indian firm perspective or an Indian law firm, we generally do not get that opportunity wherein we are required to do sanction checks as such. But I can see that, it's the near future wherein that market is going to grow in India as well, where Indians will be running sanction checks to see if they can transact or not.
No, that's great. Thank you for the inputs, and Dimitris, thank you for highlighting that as a pertinent risk, which we should continue to see in these uncertain times. Turning you to now, Ruchir, I would like to kind of, you being working as an external counsel for the ship owners, what in your view brings that dimension which needs to be kept in mind while dealing with any vessel casualties, especially in the Indian territorial waters?
Yeah, so today I'm going to tell you guys about basically the Indian perspective of any ship, foreign flagged or Indian flagged within the Indian waters, coming across an incident or a casualty. So there are a number of authorities that would be involved depending on the kind of casualty. If it's a fire, an explosion, listing, the vessel is going to sink, it'll be an emergency response, which is generally given by the Indian Coast Guard or the Indian Navy, depending on how far the vessel is out in the sea. There's a statutory authority called the Director General of Shipping, which generally oversees everything water-related, which will basically be overlooking at what the Coast Guard is doing. If there's any oil spill response that needs to be conducted, crew safety, they're just the overlooking body. Then you have the Mercantile Marine Department. Each area in India is divided into nodal MMDs, which basically will conduct the investigation, will go talk to the crew, take the crew statements. Now, by chance, if the vessel has an oil spill or there's an explosion, there's a fire, and there's some kind of pollution, then the State Pollution Control Board or the disaster management authorities will come into play. If, for example, the vessel has come into collision with another fishing boat or there's a loss of life, then the coastal police gets involved. And the coastal police in India has the jurisdiction till 200 nautical miles. So they, similar to the MMD, they also have nodal offices dealing with it. Now, coming to the investigations, there are two types of investigations that you need to look out for. One, like I said, is the Mercantile Marine Department, which will be conducting the civil side of investigation as to what went wrong, ways to prevent it. And then there's the coastal police. If, for example, there's a collision with another fishing boat, and we've seen that happen more in the southern states, where basically off the coast of Kerala and off the coast of Tamil Nadu, I guess it's because there's a lot of bottom trawling that happens over there. So the fishing boats go out deeper into sea, and they tend to collide quite a bit with ships. And it's also seasonal. Like we've seen that there's a rise just around monsoon time, and then it falls down again. When the MMD is conducting an investigation, it's basically a preliminary inquiry that is conducted. If there is some wrongdoing or there's some further investigation, formal investigation that needs to take place, then you can approach, the MMD approaches the court. It may approach the central government, and the central government may also direct for a formal investigation to take place, and the court will conduct the formal investigation, commit a person for whatever crime or whatever they come across. Then after that, you will come across criminal proceedings. Now, Hari in the last talk already mentioned it, so I'm not going to cover it in too much depth. But the idea is that, like I said, the coastal police has the jurisdiction up to 200 nautical miles. So even if there's a collision far out of the 12 nautical mile limit of the territorial waters of India, the Coast Guard will act and bring the vessel in. And then after that happens, they are going to basically conduct their investigation. So there will be a parallel investigation being conducted by the MMD and a parallel investigation by the coastal police. They will take their own crew statements. They will have their own procedures to be followed. And the MMD will also take their own procedures. Now coming to the claims. So I had the experience of dealing with a vessel that recently sank off the coast of Kerala. In that situation, there were a number of claims. Before we get into the claims, there were a number of litigations that came into being. One was a public interest litigation where a lot of parties filed proceedings trying to protect the environment because they were worried that, because of the vessel sinking, there's oil, cargo, etc. on board the vessel. And That's going to be a problem, so they filed public interest litigations to get the state to act. Apart from that, there was something called the National Green Tribunal, which took suo motu cognizance, which deals with basically the environmental aspect of the country and environmental laws. And they also took cognizance, and they have basically served the owners, and that proceeding is still to happen. Apart from that, we came across a lot of cargo interests which were making their claims. We came across a lot of fishermen who have filed claims for both loss of earnings, whereas damage for their fishing boats, because they're saying that the vessel or the containers have caused damage to their fishing nets. They're unable to fish in that area because it's been blocked out. And interestingly, then we had this massive pollution claim from the state, a $1.2 billion claim from the state, out of which about $1 billion was towards pollution, and more specifically oil pollution. And this is where I guess Dimitri would have a couple of things to say, because the entire reason or the rationale behind the $1 billion claim was that the club cover for oil pollution is up to $1 billion. So it's not like a blank check. You need to definitely, under Indian legal proceedings, you need to prove your claim and prove your damages. But this is a big claim that came in, and it's still in court, so I'm not going to mention much about it. But that's something that we need to look into, wherein you are exposed to these wide gamut of claims, and it causes a lot of problems. Apart from that, there are conventions that do govern Indian proceedings, especially in case of casualties. It's the Civil Liability for Oil Pollution CLC Convention and the Limitation of Liability Convention. We have up to the latest protocols in place in India, but we don't have the wreck removal convention or the bunker convention in force in India. The new Merchant Shipping Act is trying to bring that into force, and hopefully that comes into play. So you can limit your liability in India, and for some reason there was, the Indian government did not incorporate Article 4 of the Limitation and Liability Convention, and therefore you get an absolute right to limit liability. There's no way you can break limitation over here.
It's interesting.
And yeah, now coming to just some things that you would want to keep in mind in case something like this happens, like what do you do? Operational risks, and how do you deal with the emergency? So the first thing that I would recommend, and we came across this issue, was that you should have a one-stop shop team for communication. When a casualty is happening, more than exchange of information or trying to find who's liable, it's more about trying to give information to the authorities so that they can act and assist. So communication, a good communication channel should always be there. Secondly is collecting vital evidence and information. You have to have the ECDIS data, the VDR data, any CCTV footage, getting crew statements, all those when it's all fresh is really important, because later on there are multiple authorities meeting people, there's multiple discussions, people are talking to each other, and then the information disintegrates. So that's something that's really important. You need to make sure there's some kind of media level management depending on the kind of and nature of casualty it is, because if it's a collision with a fishing boat, the fishermen community get agitated. So maintaining a good image and communication is key. Apart from that, you should prevent the crew members actually from posting things on Facebook, posting things in the social media, because the moment a casualty happens and the investigators are involved, it's an active investigation, and you don't want random information being disseminated into the open media. One very important thing that you should do is call a lawyer, because they will help you understand what are the regulations, what are the requirements, intimations that you need to give, how do you protect the owners, the crew members, and just a base to explain to you how things go.
Thank you very much, Ruchir. I think it was very insightful, and it gave a lot on how you could be more prepared in order to proactively deal claims if they arise in the jurisdiction and the territorial waters. Thank you for that, and then there's always lessons to be learned at the end. Coming to you, Siddharth, from what has been already been covered, what do you think, if there are any other risks which you still see are out on the horizon or keeps you thinking over the night?
I see that we got 3 minutes, 18 seconds.
Yeah, that's fine.
I mean, I think since 2020, we've had like this surge of issues in the shipping industry. Started with COVID, and then we had the Russia-Ukraine war. It kept lawyers busy. And then the Suez Canal crisis, of course, where you had the Houthis attacking ships, unfortunate deaths of crew members. And then we had Trump and the tariffs. And I came in today thinking I'll speak about Trump, tariffs, and yes, as Jacqueline mentioned just a few minutes back, that they've suspended the tariffs, especially in the shipping industry. I think, but that is important to bring you back to regulatory changes in shipping. Geopolitics is the epicenter today, ever-changing alliances, new alliances. And in that context, I think I'll just keep it brief and just say that when chartering teams, business people are going out in the markets, they need to be conscious of the fact that the markets can change against them. And a sensible thing would be to have clauses which take into consideration that there could be regulatory changes, which then allows them to come back and negotiate terms some way. You have the hardship kind of clauses, for example, in French law, which are very common. You can have clauses like bunker adjustment factors, but you just change that for tariff adjustment factors. Those kind of solutions are there. But I think it's very important to have clauses which allow you to pass the liability to your counterparty. I'll keep it
Great.
short.
No, that's very insightful, and I understand even from the lawyer's hat, you have to be innovative. It is a great thing to be. Dimitris, do you think you have to add anything to what Siddharth mentions?
Very, very quickly. Just on maritime casualties, I think
Yes.
two concerns, one clarification. First concern is the increasing criminalization of seafarers. We spoke about that earlier, so I won't go on it again, through it again. In terms of the clarification, I think when we talk of maritime casualties, roughly we can see them as salvage operations or wreck removal operations. A reminder that, from my perspective, the P&I Club is almost entirely responsible for the wreck operations, but before a wreck becomes a wreck, it usually is a salvage operation, yes. And in that regard, it tends to be a hull and machinery obligation to deal with it, unless there are pollution risks, environmental concerns, in which case the P&I Club kicks in through a scopic clause. And then very, very quickly, my big concern right now is that there was a recent incident in a neighboring country where, for all intents and purposes, despite the club in question complying with its obligations under the various IMO regulations, we have seen the state in question effectively requesting an exorbitant uplift in fees, which does not be substantiated by the conventions, and that creates a risk for the involvement of insurers in these instances. That's it.
Right. Oh, thank you. Ruchir, do you want to add anything to what Siddharth mentioned or anything from your side? So no, that's very good. So if I have to summarize the key takeaways from what we have spoken, then I think we have to understand that there might be a need to keep balance overall, and I think that sanctions will come and then things will change, which means there will be uncertain times. I think, and the trick will to keep the trade moving is about finding the right balance, probably. Lastly, when it comes to casualties, I think if I have to summarize, if I have correctly understood, it's call the lawyer or call your club as and when things happen, and do not delay your notifications of the claim. I think as if we're there, it's very important to do proactive claims handling rather reactive to ensure that you can preserve your evidence, get your investigations correctly documented, and show the cooperations which you will have to do with all the authorities in the equation during the crisis, keeping your media also abreast. Okay, That's very good, and I think that is all from our side in order to sum up the session, and I hope I kept the time. And thank you very much to Sanjam and Maritime CEO for inviting us all to talk on this evening, and also to India Maritime Week and the authorities for taking the interest in taking the maritime industry forward. Thank you very much, ladies and gentlemen.